As we're beginning to call it a wrap, we'll be focusing on a few other topics that I consider very essential to business and commercial law. And before we proceed to our next topic, which is intellectual property, I would like to say welcome back. So let's talk about intellectual property. Intellectual property, popularly known as IP, is a multifaceted subject which makes it complicated to know where to start or how to even begin. But here you can find attempted answers to some of the most common questions asked. For detailed legal advice, consult an IP lawyer. So, what are the frequently asked questions on intellectual property? What are the common questions that arise on the issue of intellectual property? What is intellectual property, by the way? Is it based on the view of the World Intellectual Property Organization, WIPO? IP is a product of the mind which includes inventions, literary and artistic works, any symbols, names, images, and designs used in commerce. Be careful to note that the distinction between IP and IPRs, that is, intellectual property and intellectual property rights. Intellectual property rights are legal forms of protection for intellectual property, and they fall into four main areas, which include the patent, the copyright, the trademark, and the design rights. Sometimes the common law right against passing off is construed to be a distinct part of that list. Remember, four main areas: the patent, the copyright, the trademarks, and the design rights. Passing off sometimes happens to be included in the list. So why is this important to you? Why is this important to you? Why is intellectual property important to you? Intellectual property is important to you because if you generate IP that an intellectual property that you wish to protect and which you think might be able to be exploited for some benefits, you may want to consider how to legally protect your rights and what rights you already have. Further, you need to also realize that others have rights as well. Example, anyone with whom you have collaborated or in whose work you have been involved, for instance, like an employer, may have an interest in any IP rights generated as a result of this work. And anyone whose work you used, do you understand? Anyone's work you use needs to be referenced appropriately or acknowledged. So, if you're thinking of protection, if you have anything that you feel is worth protecting, good, welcome to the club. You can try and protect it. But while you're trying to protect it, notice that some people have rights to use these things you're trying to protect with you. And the instances are listed: 1, your employer. If it can be ascertained that it's at the cost of your employment that you stumbled into this intellectual property rights that you're trying to protect, because it will presume that he has already, being your employer, has paid for your services. So these rights are rights that should be enjoyed with the organization. Other people include people that worked on the things they are trying to protect, the discovery, the innovation. Others include the people that you referenced in your work, the people that you recurse to their own work to get about your own work. You must acknowledge them, you must give them credit for their own efforts. But you may be wondering, what can I protect? Remember, I said you can protect your works, that falls under patents. You can protect how your product looks, that has to do with registered designs. You can protect what your product is called and the slogans that gets, the get up words that come with your product. That falls under trademark. You can also protect what a product says. That falls under copyright. Yes, that falls under copyright. So 4 things: patents, registered designs, trademarks, and copyrights. So question now, what is patentable? New products are patentable. Improved parts and features of products are patentable. New or improved methods and processes are patentable. New uses of unknown things are also patentable. Yes, software. Well, this is only patentable if claiming a technical effect is dicey, is neither here nor there. Question now arises, which countries are covered by my patent? First is the country where the patent is generated. But if, for instance, you want protection in other countries, let's say for instance in Europe, you need to file further applications through the European Patents Convention (EPC), the Patents Cooperation Treaty (PCT), or individually if the countries that you seek protection in do not belong to either the EPC or the PCT. In other words, where you generated your copyrighted your item, your creative item, is where you can file for the patent or the protection. However, the way the EU is structured, there are institutions set up that can regulate copyright in the whole of the member states of EU, so you can file your rights there. But that does not mean that your rights cannot be infringed in other countries. So one of the ways to protect your rights is to make sure that in those other countries that you want your rights to be protected, want it to be infringed on, you can file it under there. That may be cued some rights, yeah. But if what I remember from my IP is still right, there are some IP rights that have come into public domain. The knowledge of public domain that these rights are exclusive to this brand. Therefore, even without filing for your rights to be protected in those other jurisdictions, you can enforce your rights when one is trying to infringe upon them. Again, you can't be filing for the rights or to protect things that are already in the public domain. You cannot be trying to protect things that are not novel per se, things that have already been in existence just because you rediscovered them. So it's dicey. But to clear your doubts, whenever you have an issue that you feel should be protected or needs to be protected, or you feel is about to be infringed, reach out to an IP lawyer and they will be more than willing and excited to help you. If you notice, for each subject I keep on referring to a designated kind of legal practitioner that you should consult. Reason being that there is no one size fits all when it comes to the kind of attorney that can do your legal services. You have to do what we acknowledge to be division of labor, giving the right task to the right lawyer, making sure that round holes are for round pegs. So an IP lawyer with expertise in intellectual property obviously can give you a breath of fresh air when you have IP needs. Things you may be wondering if they can be protected. Yes, for you an artist, your songs can be protected. For you a writer, your written works can be protected. For you a designer, a creative person, a technical person, those things you are developing can be protected. Yes, your codes for an IT person, your codes, your software, they can be protected. So get yourself more protected and try and enforce your rights, because the rights will not enforce themselves. Try and enforce your rights whenever you feel your rights are being infringed upon. So when it comes to protection, we have an institution in Nigeria that is responsible for the trademarks, copyrights, and all that. Consult your lawyer, they would advise you on the processes, the fees, and all things associated with ensuring that you are protected. And the price is very, very affordable. I think I've had the price before, I can't remember, but I can mention it here. but it's very, very affordable, so you don't need to rob a bank to protect your rights. It may take time before it finally comes out, the protection certificate or notices and all, but it's something that is doable. So you can be able to press an action or hold accountable anyone who infringes on these rights. So that's it in a nutshell about intellectual property. You know how we end. We keep reminding you that this is not exhaustive. We can't lean on this to make a legal decision or to act on refrain from acting. However, what we have here is designed to keep you going, get you started, get you curious. But should you have questions or you have peculiar IP related needs, feel free to reach out, send an email, and I'll be glad to take your questions. But till then, I would like to take our time to focus on something that I consider very important. And that's what I call the 5G of retainer arrangement. And that will be coming up in the next slide. We'll be talking about how do you appoint an attorney. Keep on hearing me advise you, should you have this need, appoint an attorney. Talk to a lawyer, do this, do that. How do you know who to appoint? Is it any lawyer you see that you approach and say, hey, come and do this for me? Not necessarily. If you do that, chances are they will not tell you, no, we can't do it. They will take it. But will they deliver it according to your expectation? Will they deliver on the job according to your expectation? Your guess is as good as mine. So you have to really take your time and do what we call due diligence. Employ all due diligence exercise technique possible to make sure you're getting the right person for the right job. Yes, that's what we're talking about in 5G of retainer agreement. And you may be wondering, what is 5G? We'll find out when we get there. Till then, stay strong, stay safe, keep well out there, and bye now.